I now like to move over 2 minutes early, over to the Hospital Conversions Act, the overview of the Hospital Conversion Act and the Attorney General's role as it relates to the Act, and welcome the Honorable Peter F. Neronah, the Attorney General for Rhode Island, General. Thank you for being with us tonight. Much appreciated.
Thank you, Senator, and members of the committee. It's great to be with you. I want to let everyone know that I'm here with two of my colleagues, Miriam Weisenbaum, who is the chief of our civil division. She appears on your camera as Lauren Hill because of that's the way our conference room is sending her name out, but it's Miriam. And when you see Lauren Hill, that's Miriam Weisenbaum. Many of you know Miriam. She's the chief of our civil division. And also with us is Jessica Ryder, a special assistant attorney general who is our healthcare advocate, and is really sort of the front-facing person on our team when it comes to the Hospital Conversion Act and much, much more. Before we get into the act itself, I want to talk a little bit about our role in healthcare, because I think in some ways it can fly a little bit below the radar. This office, as many people know, has a variety of functions. One of our principal functions is that of a prosecutor, and certainly we bring healthcare fraud actions. We also have a role as a regulator, and that is our role under the Hospital Conversion Act. We regulate certain healthcare transactions. And then we have another role, which is incredibly important, and that is as the healthcare advocate. And under a statute passed by the General Assembly in the late 1990s, we have a role to advocate on behalf of the people of the state of Rhode Island in really any matter that affects healthcare and the delivery of quality healthcare. And that's a role that we are taking on with increasing frequency. So we really can fall into three buckets when it comes to healthcare. So I will tell you that even before I took office, it was plain to me that healthcare was going to be one of the most challenging areas that I was going to face in the new administration, and that has proven to be true. There's no question that the volume of healthcare work is increasing, both in terms of its volume and in terms of its complexity. When I took office, Partners in Care New England were talking about a potential conversion. That didn't happen in the end. That was, by the way, an expedited conversion had it continued on its path. And frankly, that was a real challenge for us, for a conversion of that potential size to do it in an expedited fashion. Really presented logistical challenges for us. In any event, the work is increasing. As I said, it's getting more complex. Certainly, for-profit institutions are playing in healthcare in a way in the last decade or so that was not true 10, 15, 20 years ago. Sometimes those out-of-state healthcare organizations involve many, many hospitals across many, many states, involving regulators in other states. So certainly the complexity of the mission has gone up. I will tell you that we have more people working healthcare now than I think ever in this organization's history. Right now, for example, I have 6 people spending some or all of their time doing healthcare. When I joined the office, we had effectively 1.5 people doing it. So 1 person full-time, Jessica, backed up by Maria Lenz. Again, the work is just expanding. I want to thank the General Assembly for doing 2 things since I've been Attorney General. The first is enhancing our ability to monitor health care transactions, to include nonprofit conversions, and also to monitor them for longer periods of time. It's incredibly important in instances where we impose conditions and want to make sure that those conditions have been complied with. The other thing I want to thank the General Assembly for is for including antitrust review as a condition or a criteria within the Hospital Conversion Act as it pertains to the Attorney General. Now, certainly as we see healthcare organizations get bigger and consolidate, and that certainly is the trend in Rhode Island, New England, and around the country, certainly there will be efforts to do that. That's not reading tea leaves, that's just the reality. Antitrust becomes more of an issue. Before the General Assembly made that change at our request, our ability to hire experts paid for by the interested parties was non-existent. For us to be able to fund those experts would have been very, very, very difficult. We would have had to come back to the General Assembly for funds to do this. Our expert our expert budget's less than $100,000 per year across the entire civil division. And that just simply wouldn't be possible. So I want to thank the General Assembly for that. There's a tendency to conflate our responsibilities in healthcare with those of the Department of Health. And the reality is, under the statutes, as I'm sure many of you know, the criteria are very different. And we'll get into them, I think, a little bit tonight in addition to going over the process. But by and large, our criteria tend to involve things like protecting charitable and public assets, making sure that the valuation of the hospital in play, or the hospitals in play, have been properly valued, making sure that the consolidation makes sense from the hospital's perspective, that there aren't conflicts of interest on the board or among the officers. So they tend to relate to those kinds of things. But I will tell you that I view our input more broadly than that, in this sense, that as the healthcare advocate, I think it's also important for us to make sure, in conjunction with our colleagues and friends of the Department of Health, to make sure that safe, accessible, and affordable healthcare is delivered. And it's easy to say those words, but the effort to get those words right is incredibly challenging, especially today. So I will leave it there in terms of my comments. Obviously, I will stay with you and happy to take any questions you have for me. But at this point, I'm going to turn it over to the healthcare advocate, Jessica Ryder, to walk us through our approach to the Hospital Conversion Act, and also to share with you what we've been up to over the last 2 years. So Jessica, I'll turn it over to you now.
Thank you, Peter, and good evening, everyone. I will share the screen. That didn't work. Go ahead. All right, can everybody see this slide?
Yes.
Okay, great. So I'm going to go through a PowerPoint. Some of the information will overlap with what the Department of Health was saying, but there are, as General Neronah said at the beginning, there are some specific criteria to the Attorney General's office. There are some, differences in our process. So bear with me if there's some overlap here. Right, so purposes of the HCA, you already heard this, so I'm not going to go through this again. This is taken right from the statute. What is a conversion? A conversion, again, is a transfer of 20% or greater of essentially control ownership in a hospital. And I write down, I pull these directly from the statute again, just to highlight that there are different mechanisms that a transfer would take place. So it's ownership, control, membership interest, authority, or voting rights. The Attorney General is involved in any hospital conversion that's going to be, hits this threshold of 20% or more. So there's a question earlier about whether or not, what happens between 20% and 49%. But just to be clear, we're involved when there's essentially anytime there's a conversion, and that is going to be a transfer of a hospital facility. So again, under the HCA, both the Attorney General and the Department of Health are going to review and approve any and all hospital conversions, and that's required before a conversion can take place and a transaction can close. We do conduct those reviews concurrently. So the HCA process, laid it out here for you. It's going to start with some preliminary discussions, in the office, interagency, and with the parties. We're going to receive an initial application. We're going to do a completeness review. That's a completeness review of the initial application. Once an application is deemed complete, again, we're going to have that review period of 120 or 90 days. We're going to render a decision, and after that, we'll be monitoring any conditions of approval. So what's happening during the review process? Once that initial application is complete, we're issuing other written questions and document requests that might have not been captured by the initial application. We're holding at least one public meeting, maybe multiple, depending on how many hospitals are involved or how many different stakeholders we need to hear from. We're conducting statements under oath. These are essentially deposition style interviews that we're doing under oath of key players here. So we're talking about, CEOs, financial people, board members, other stakeholders as necessary. That's what we're doing there. Hospital tours, that was something pre-COVID, obviously not a priority necessarily to get the Attorney General's office in a hospital right now, but in the past that's something we've done and plan to do in the future. And then, other investigations as we see fit, as issues come up. So just want to go over briefly the initial application and the types of information that our office is receiving. And just to be clear, that is, for the most part, a joint application. There are definitely certain instances where the application, the HCA application, is not a joint application, but for most reviews, it's going to be joint between the Attorney General's office and the Department of Health. So statutorily, there are 42 items that would be in an initial application. It's very expansive, but these are just kind of the key areas that we are getting information on. So proposed conversion, we're going to get a summary. We're going to get the transactional documents. We're going to get the consultant's reports. We're going to get the RFP information, due diligence, governance. We're going to get the organizational charts. It's going to be pre and post conversion. We're going to get bylaws, articles of incorporation. Again, all as they currently stand and what's proposed after the transaction. For financials, we're going to get financial information, financial statements, debt information, budget information, their capital budget, their operating budget. And again, that's all going to be as is. And then what's the plans for the future, right? For the board of directors, we're going to get minutes from board meetings. We're going to get a rundown of all the different committees and subcommittees that the various boards have. We're going to get all of the board members' information, as far as contact information, who they're associated with, etc. Compensation of the board is also something we get. And we're going to also get that information for senior management. And same thing there. It's also as it stands today and what's proposed, who's going to be on the board after this thing goes through. For conflicts, we're going to get conflicts of interest statements. That's going to be a signed attestation form by each person that's required to file one. We're going to get conflicts policies of the different entities. We're going to get relevant employee agreements. Specifically if there was, a key employee, senior manager, board director that left right immediately before we got our application. For facilities, we're going to get patient statistics, info for all the different licensed facilities that the parties maintain. That's going to be in-state and out-of-state. So if we have someone coming in from out-of-state, we're going to know where else they have licensed facilities. Different citations and lawsuits. So, tying that back to their facilities, in what's going on in Rhode Island, we might know, but we're going to get information from all their different facilities. So if they have some citations, lawsuits going on with some other hospitals in other states, we're going to know that and be able to evaluate that as part of this process. Charity care information, staffing levels, and the service plans that they have. And to round this out, for the charitable and nonprofit information, to the extent it's applicable to the transaction, we're going to get charitable asset documentation. So that's going to be founding documents, what restrictions there are on certain charitable assets. We're going to get accounting so we can ensure that the assets have been properly distributed. We're going to get a proposed side price. So if the mission is changing, this is especially going to be important if it's going to be from nonprofit to for-profit. Still important from nonprofit to nonprofit because essentially sometimes the mission might change a little bit. And, information regarding any tax implications. Again, very important if they're going from nonprofit to for-profit. So again, the review period, we talked about that a little bit earlier, the different things we're doing during this review period. And then we get to the Attorney General's criteria, and this is where there's a diversion, and I've done it as 6 main categories because we actually have, the Attorney General's office has 31 criteria to review for a for-profit acquiring a nonprofit, and 22 criteria to review for any nonprofit to nonprofit transactions. So I've broken them down into buckets here. So we've got governance, conflicts, charitable assets, antitrust, valuation, and transacting parties. And for governance, what we're really looking at here is, the board's review the board actions pre and post transaction, their due diligence regarding the transaction, when it comes to the process they went through, the negotiations, the value, the purchase price, and any other considerations there. And then we're going to be looking at the governance structure post-transaction, how it looks different and why. For charitable assets, we're going to look at a proposed conversion's effect on charitable assets. We're going to look at whether or not fiduciary duties were followed through and consider those. Again, if there's a cypre necessary, nonprofit considerations, and if necessary, a foundation for the assets. Conflicts, we're going to be, kind of generally looking at any conflicts of senior management, board, or consultants, employee or board agreements or promises related to the transaction, whether or not they're going to be retained, and if that was in an agreement, and the appropriateness of all of that. For antitrust, that's going to be a review of whether or not this transaction is appropriate under the Antitrust Act, looking at competition and whatnot. For valuation, we're going to be assessing the appropriateness and reasonableness of the purchase price. That could also include any capital commitments or other things that are related and go into that purchase price. And then for transacting parties, what we're really looking at is the character, commitment, confidence, and standing in the community. Who's coming in to buy this hospital? Let's assess them and whether or not they're good for our communities. So again, use of experts. I know this was already briefly touched on. We can engage experts or consultants to assist in our review. Typically for the Attorney General's office, what that's looked like is outside healthcare regulatory or nonprofit counsel, valuation and financial consultants and experts, and moving forward, antitrust consultants. So then we get, after our review period, to the decision. And again, that's going to be within 120 days of acceptance of the initial application, either approving with conditions or denying. And the conditions are going to relate to the proposed conversion, the review criteria, or the purpose of the HCA. So any of those three. And a final slide here. These are the transaction reviewed or monitored by the Attorney General's office in 2019 and 2020. So just a couple of key points here, and I will turn it over to Miriam Weisenbaum, who will talk about this in detail.
Hi, thank you, Jessica, and thank you, Chairman and Senators, for giving us the opportunity to talk about the work that we do in the realm of the Hospital Conversion Act and related work. I want to, as Chief of the Civil Division, I want to underline some of the things that have been referred to by both the General and by our healthcare advocate, Attorney Ryder. But before I do, I wanted to go through this this list, and then we'll be able to take it down. Because one point that that the General made reference to that I really want to bring home is the magnitude of work that the office is doing through the Conversion Act to protect these critical community assets. So just in 19 and 20, we have, as you can see, we're currently involved in a review application of a change in ownership at the higher corporate level, the national level, with Prospect Charter Care, which, as I'm sure you all know, is the hospital that owns Roger Williams and Fatima. Attorney Ryder made reference to our monitoring obligations, and those are ongoing after a transaction. So, for example, with respect to Prospect Charter Care, the first transaction, when Prospect came in and purchased those hospitals, in 2014, this office placed conditions upon their purchase of the hospitals, again, to ensure, that North Star, that there's viability of safe, accessible, and affordable health care that you all have given us in the statute and is the priority of this office. So the monitoring helps ensure that. And in that case, it really had to do with financial commitments. And just going on, Prime acquired Landmark in the 2013 transaction. There's ongoing monitoring with that. Some ongoing monitoring with Yale New Haven Westerly. And then currently, we are involved in another phase of the conversion process, and that is what we think of as pre-review. So before an application is filed, parties will notify our office that they are intending to engage in a transaction. And in this case, Lifespan and Care New England have notified our office and made public that they are looking to consolidate. And I'm not telling anybody anything they don't know. This would be an enormous, if it were approved by our office and Department of Health, would have an enormous impact on healthcare in Rhode Island. And so this is a huge responsibility, and that's one reason why almost 25% of my staff in civil division are working on hospital conversions right now. And the pre-review involves beginning to gather information, and also a very important part of the process is retaining experts. And this is a function of the General referred to, the amendment to the Conversion Act that added antitrust review to one of our criteria, and importantly, placed the burden on the parties to pay for those experts, which is just absolutely critical. These are incredibly complex questions. We're still the attorneys running the investigation and the review, but we need people to help us identify and work with us. And for those of you who've done litigation, you understand that. So as we prepare for the filing of that application, we're gathering information and engaging experts. And then, and we also included on here the partner C&E, where the application was withdrawn. That was in 2019, but also a huge transaction. Thousands and thousands of pages of documents. And I think our healthcare advocate might be sort of understating the magnitude. We pulled just our sheet to keep track of where we are and on any one of these. And for prospect, for the current prospect application review, we have done a total of 196 distinct questions to the parties. That means that there's a question, and then there's follow-up, and then if there's not enough information, there's more follow-up. It's an incredibly detailed process, and I think very appropriate for this office because it is like a litigation. All in all, we've evaluated for confidentiality and, of course, for content, almost 6,000 pages of documents. We've so far done 9 interviews, many of which go for most of a day. It's a very, very involved process. But I want to also drive home the fact that this is a really critical tool because it gives us the flexibility to change based upon the healthcare environment. So, for example, there was a question from Senator Kalman about an article that was in the Globe concerning rate negotiation between hospitals and insurers, which is a place where, there really can be some mischief. And because if they're making agreements that hurt consumers and aren't visible, then that's really a problem. And as it happens, that's also something that we look at very closely in an antitrust review. So, well, it's not a particular criteria in the Hospital Conversion Act. It is absolutely something that we'll be looking at closely. And again, this is what is so important about this statute, that it gives us those tools. I want to mention a couple of other things that didn't come up so much in the presentations. One is that the HCA also gives us enforcement tools. So if the parties are coming to us and they're not being forthcoming, we can issue a notice of violation. We impose at the end, if we do decide to approve a transaction, what's really important is we can place conditions on that, and we have enforcement abilities with the conditions. And I think it's important for you to know that we really enter this arena with some meaningful tools. I think another a question that has come up, certainly in the course of my conversations with some of you all, is what happens when a for-profit entity comes into the state and wants to, or does, own our hospitals? How do we protect people, patients and workers, so they are not displaced by the primacy of profit? And we do that through these reviews. We identify the strengths and weaknesses of the entities and where we can install protection. Because whatever the driving interests are of a proposed acquirer, it's our job to figure out which conditions can accomplish that protection, so that patients, workers, communities are protected through the process, even with a for-profit. And there are of course limits to any tool, or as you might think. One way to think of it is, if this is justice, this law can get us pretty close. And it's our job to just keep pushing that until it gets as close as it can. So I think those are the points that I wanted to make, and I wanted to make sure that we have time for questions. So again, thank you.
I was going to say Lauren Hill, thank you very much, but I won't. Yeah,
I'm sorry about that. I had to come down to the conference room.
That's okay. And General, thank you very much. Questions for the Attorney General and his team? So I have one. General, thanks for you and your team, all the work of the director. Thank you very much for being here today and talking about this important topic. We will be, I'm sure, talking about it again, probably sooner than later, but we'll become good friends if we're not good friends of seeing each other sooner than later. I'm reminded of the work of your previous colleague. He's not your colleague, well, I think he's still your colleague until it gets confirmed. Xavier Becerra, I'm not sure how you say his name, from California.
Yes.
He's going to become the Secretary of Health and Human Services in the Biden administration.
Correct.
He had a segment on 60 Minutes. I thought it was a profound segment back probably a month and a half or so ago, well before the announcement, talking about what he saw in his home state of California as part of the Attorney General and what he needed to do. So a couple things. Given what's happening now, I know very little bit about the hospitals, what's happening outside of Rhode Island. I think I know learning more about what's happening within Rhode Island over my 13 years in the Senate. But how does this must be an area where AGs across the country must interact to a great degree because of what's transpired out in California and what he did, like the 43 million people they have out there. What are you hearing across the country that, and I ask this from the perspective of, one, what are you hearing? And number two, from an HCA perspective in the Rhode Island general law, similar question asked of Dr. Scott, Alexander Scott, what needs to change? So macro, what do you hear nationally, and then bringing it down to the micro level, what do we potentially need to change from an HCA perspective in Rhode Island?
Yeah, Senator, thank you for that question. I think the first thing I need to say is that not every Attorney General has this regulatory power, and so this has come up in the context of Prospect, where Rhode Island, ironically, is one of the few states, even though Prospect has hospitals around the country, we're one of the few Attorney Generals that has regulatory authority. So, you know, this is an interesting thing about Attorneys General. We are very different in terms of our scope of authority, particularly on the criminal side. You know, we are, in this state, we are very different from AGs around the country. We have the DA function here, for example. Many of my colleagues have no criminal responsibility at all, and when they do, it's quite limited. So, you know, certainly while, you know, we rely on colleagues, just as I did when I was U.S. Attorney, to talk to others around the country, it's not exactly always comparing apples to apples. And so, you know, we tend to rely on our own experience here in the office, trying to recruit, as I believe we have, a strong healthcare team, and then hire experts that can really assist us. You know, I think if you're asking me what could change in Rhode Island, you know, look, I think the General Assembly has been very receptive, you know, particularly on the Senate side. You know, the Senate President, I believe, was really the moving force behind these amendments to the HCA the first 2 years of my administration. Really grateful for that. I think what we could do better as a state, if you're asking me to go to 50,000 feet, although a 50,000 foot level here in Rhode Island is to think more strategically as a state about what we want our healthcare regulation to look like. You know, Jessica mentioned to me today while we were meeting about how a lot of our changes in the HCA have been sort of, as she described them, one-offs to respond to particular situations. I think we need to do a lot more strategic thinking in the state, not only in this office, but as part of the overall executive branch. Of course, assisted in that by the General Assembly. You know, if we're not really thinking at a really high level about how healthcare ought to be delivered today, then I think we're doing ourselves a disservice. You know, we tend to go into these, we look at these things as transactions, and we never really think about how do we want to deliver healthcare. As many of you know, I'm married to a primary care physician, a member of Coastal, who delivers care in a certain way and has been doing it for a very long time. I tend to look at healthcare through a primary care physician's lens, just what I've lived with, and I believe in primary care and delivering healthcare in that way. But as we look at these transactions, or even if we're just plotting strategy, how do we deliver healthcare that's quality and is accessible and affordable to everybody in Rhode Island? As we go into some of these healthcare transactions, are we abandoning neighborhoods? Are we abandoning neighborhoods of color or of the impoverished? Those are things we have to think about in the context of each particular transaction, but I think we ought to be thinking about it at a much more strategic level. And I think that strategic level thinking does not exist, at least very robustly, in the state.
General, thank you very much. I guess we'd be looking at maybe we'll follow up at some point to say, how do we do what based on that need and that I'll say goal you're calling out or request of a certain deficiency we have, I'll put it in a positive way. What should be changed? Because right, if we look at these transactional, we'll get to a certain point, at some point, look back and say, if only we had and put those pieces together, thought in a more strategic, we might have made steps 2, 3, and 4 instead of playing. So instead of playing checkers, we should be playing chess, right? It's from the strategic.
Yeah,
okay. Other questions from the committee? Senator Acosta.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, and all your team. I actually have a related question to this, and it seems to be the case, and thank you, Ms. Weisenbaum, for answering or for addressing Senator Coleman's question, that it's actually in the sale that we learn much more about hospitals than we do at any other point during their operation. And so the things we would like to know are coming in the process of them having to disclose information. And so I would like to, we're scratching at it now, but think through, is this the realm for the Attorney General's office, or is this actually something that should be housed in the Department of Health? But how do we better essentially regulate hospitals so that it's not just when you're selling or buying that you have to disclose this information, but either on a 2-year or a yearly basis or whatever, so that we have informed consumers of healthcare, but then also regulators, because it seems to be the case that we only find out what people are doing when they're either going under or when they're kind of turning on a hospital system that's going under.
Yeah. I can take that. Yeah. You know, I think you're really, really right. And so this is where, you know, those tools like get us partway there. Because at a recent amendment to the Conversion Act, it extended the monitoring to 5 years, which, you know, is kind of a blink of time, but it's not nothing. I mean, right? So one tool that we can use is we can place conditions and then we can monitor for them. But going back to Senator DePalma's question, what else do we need? Kind of dovetails with this, because what we really need are resources. We need resources to be able to meaningfully monitor. Now, the monitoring under the HCA is paid for by the parties. Okay, but it's independent. It's not their monitor. It's we hire the monitor and they pay for it. Great. But I think that, and with a, you know, depending on the size of the transaction, you can be gathering a lot of information. But what's really key is making sense of it, right? Because, you know, it's really easy to drown people in information and not, again, to use the general's term, not be strategic about it. I think what we need are resources that are sustained beyond just a 5-year monitoring period. The other thing I think we need is we need to know the questions to ask. And I think that is born of not only experts, but also what I think is also the commitment of this office, which is to recognize that communities have more to tell us or additional information to tell us beyond statistics and experts. So I think it's bringing those things together, and that gives us a fighting chance, because you know that you know the entities themselves are paying close attention to the data, right? I mean, no question about that. We need to do as good a job, but we need the resources to do it. Senator, I think you're muted.
Thank you. I try to unmute. I try to follow my own rules, but I'm not listening to myself. So, with regards to, you talked about antitrust, I think earlier, as it relates to hospitals. The one thing, Miriam, I didn't hear you mention. You mentioned nonprofit or not-for-profit, not-for-profit. You mentioned not-for-profit, profit. You didn't talk about the profit acquiring a nonprofit, or did you?
No. There's not a specific provision of the Act that addresses that the way there is for the other you know, combinations you described. However, the Act clearly assigns the Attorney General the with respect to the Attorney General, that is. However, the Act clearly assigns the Attorney General the responsibility to be involved in any conversion, a qualifying transaction. So that's why we're involved, even if it is for-profit to for-profit.
So more follow-up on that, and Senator Coleman next. Any reason? Should it be changed? Should the Rhode Island General Laws be changed to be explicit about it? Any reason it wasn't there before?
Again, I think to Attorney Ryder's point, you know, the Act kind of grows as needed, which isn't necessarily terrible, but it makes for some gaps. And I think maybe making it more explicit wouldn't be a bad idea. I mean, you know, drafting should be done carefully, as you know, but I think it wouldn't be a bad idea.
Thank you. Senator Coleman.
Thank you, Mr. Chairman. I'm curious about what the rough percentage of transactions that have been approved versus transactions that have been denied, I don't know, in the past 10-ish years, and what the denials are for, primarily, to the extent that there have been any.
I think I'm going to ask Jessica to take that one on. I've only been here for 2 years, Senator. So my whatever I've seen, I've been in Rhode Island for that long, but it's been a distance, obviously. I'll let Jessica get into the details, but my sense is that in many instances the parties withdraw the applications. Whether there have been affirmative denials, Jessica can answer that. But from what I can tell from a distance, many of them have gone through the process and then ultimately withdrawn. So, I think sometimes, anecdotally, I've heard that sometimes because the process goes on, in their minds for a long time. When it goes on for a long time, in my mind, it's because we're doing the appropriate due diligence. I think, one thing that's very important to me is that we exercise the amount of oversight that is necessary, even if that takes time. I didn't come here to be a rubber stamp for these transactions. We're going to ask, the tough questions and make sure we get the information to try to reach the best possible result. So, Jess, I don't know whether you have a perspective on that, since you've been doing this longer than I have, for sure.
Hi, yes. So from my knowledge, going back to 2012, or actually even I would say 2009, it's my understanding that there haven't been any that have been outright denied. The act has been around longer than that, and but at least I could say safely since about 2010 going forward.
There have been a number, as I said, that have not made it over the finish line, and there are many may be an overstatement, but several for sure. Partners Care New England being one on my watch, for example. And then there's some others that are sort of a little smaller that fly below the radar. When we talk about conversions, we tend to think hospitals, potentially combining. But there are some, as Jess's slide suggests, there are some that are changes in ownership or changes in control, even if they're just over 20%, that may on their surface seem to be somewhat minor. And yet they would be subject to our review.
Thanks.
Senator Acosta.
I'm all set. That was my previous question.
Very good. Other questions for the General? So, General, I have just a couple more. When we look at, I'll say, other circumstances, and I'm not going to ask you to talk about a specific review. In the case of, let's say, Prospect Charter Care, I assume you look at things beyond what you've talked about in antitrust, other extenuating circumstances, such as the case of, we're not talking about the specific situation, the case of the pensions. So putting that aside, when you're looking at a particular application, you look beyond, as I'll say, especially just what you're handed.
Yeah, look, I mean, for me, first and foremost, it's just generally speaking, I'm asking myself, are these hospitals going to be viable into the foreseeable future after this transaction's over? And viable just doesn't mean that they'll exist. Viable means, will they continue the mission, or better yet, expand the mission of what it is they're there to do? And that's to provide really strong quality health care to everyone in that community. And not just in the physical plant, but if they've been delivering health care on sort of an outpatient basis or at satellite facilities, will they continue to do it there? So yeah, we're really looking at this very carefully. It's, how do I put this? It comes up in other context, Senator. I view us as being active in these areas. We should be active. We shouldn't let cases come to us and then sort of look at them without, in a way that's not very robust. So what do I mean by that? We should be always looking to expand our authority. The way we should be looking at healthcare problems, and frankly, every problem that we deal with in this office is, if there's a problem, we are the people's lawyer. We are there to speak when no one else can speak. We are there to act when no one else can act. And we should look at everything we do through that lens. And so in this context, as a regulator, what we're looking for is, look, something is going to change potentially around these hospitals. Is that change going to be a positive or a negative? And if we're not sure, then we need to put conditions in. We need to put conditions in to make sure that it works out in the way that we intend it to work out. So we look at these transactions very carefully. You know, I go into all of them, or proposed transactions, very carefully. I go in with a healthy dose of skepticism, really in everything that we do around healthcare and frankly around anything else. And so convince me why what you're doing or what you're proposing to do is for the benefit of the people of this state. And if the answer isn't in the affirmative, then I'm not going to approve it.
Thank you. General, going back to a comment, the excellent question that all the senators have asked. Senator Costa asked a question with regards to, we certainly do find out a lot about hospitals when they're going through this process, right? The doors are open, the curtains are open, and here it all is, based on the, Miriam indicated that thousands of pages, I'm sure, numbers of questions and hours of testimony. Balancing what's confidential to the public interest. How do you determine that balance? Because at the end of the day, hospitals, largest industry in the state of Rhode Island, right? Healthcare, largest industry in the state of Rhode Island. It is the one thing that affects the most people. The other thing that affects, second that affects most people in the state of Rhode Island is the Department of Motor Vehicles. Think about the number of people that have 800-something thousand cars out there, licenses, etc. Healthcare affects everybody in a very critical way. How do you balance the facts and data and information you retrieve and you gain so that the public, back to the senator's question earlier, the transparency, so the public has an appreciation of what's being said, what's not being said, and go back and do their own work and provide feedback maybe?
Yeah, look, that's one of the biggest challenges we face, and all of you senators are absolutely right to raise it. You know, certainly when you're talking about large healthcare institutions, for example, in a typical consolidation or conversion, you know, there's confidential business information that they want to keep confidential for purposes of running their business. We understand that. On the other hand, you're exactly right. You know, our decisions and more importantly, the bases of them ought to be transparent so that everyone can judge them now and down the road, and also have input into them as we're going forward. So we really try to be very thoughtful about that, to try to strike the right balance there. In fact, there's a provision in our process where we have to make confidentiality determinations. You know, for some of the specifics of that, I'll turn that back over to Miriam or Jessica, but you're right to hit on that. My own instinct is to turn everything over. I mean, that's just where my instinct is. And so my folks, you know, appropriately have to push back as to why that may not be possible. But that is something that we definitely look at very carefully. Miriam or Jess, do you want to weigh in on that?
You know, the only thing I'll say, and Jessica's really, I think has a closer understanding of the particular provisions that determine these confidentiality determinations. But you know, I was thinking, okay, what's going to happen in court, right? Because there's a law around it. So, you know, as much as we may want the public to know whatever it is, you know, we can't keep running to court and asking for things where we're not going to prevail, because there's law on it. But I don't know, Jessica, if you want to speak to that too.
Sure, thank you. I will just say that we look at this, all of the confidentiality requests, when we're looking at them, we're giving them really, you know, strict scrutiny, understanding that and trying to play that balancing act. And you know, we often go back to the parties and really say, you know, tell us why. Why do you really need this confidential? And I will also say that, you know, a lot of the information that we might hold as confidential is, you know, people's personal information, you know, maybe some employee information, stuff like that, that is protected in other areas. And so we are, you know, respectful of that. But I would say that it's something that we do look at, and you know, just because a party stamps as confidential doesn't mean we're not going to ask the tough questions as to why does it need this designation.
Thank you. Other questions from the committee? General, this is the last question. We talked earlier about us being compared to California and others. If we wanted to be an exemplar in what the Rhode Island Attorney General office needs to do as it relates to hospitals, which state would we want to pattern ourselves after?
Well, look. I think we have the ability, Senator, to do a great job right here with the staff we have here. You know, look, there's a reason we went from 2 people doing healthcare to 6. That's 6 out of 28. I mean, when I got here, the vast majority of my civil division was defending the state when the state got sued or when there was a policy choice by the General Assembly or the governor that raised constitutional issues. You know, we have had to divert resources into this area to address the challenges that face us. You know, we haven't added lawyers. We've just reassigned them effectively, which means as we go up in some areas, we have to go down in others or find efficiencies. Look, I'll say this about the Department of Health, too. Look, it's a heck of a lot easier to talk about resources when you're talking about somebody else's organization, because I don't want to be perceived as standing here asking you to give me more. We'll make it happen with what we have. We keep really good people. But I will tell you, to make healthcare regulation and oversight better, we need to empower the Department of Health with the budget that will allow them to do it really well. Somebody should ask them. Don't make them come in and tell you what they need. Ask them what they need, as you just asked me, Senator. And I think what you'll find is that they need more on the regulatory side of the house. And, you know, you talked a little bit earlier about having a conversation about how we improve healthcare. The best way to do that is to get really bright minds around the table and start thinking about how we move healthcare forward in this state strategically. We haven't had a written healthcare strategy in this state since the late 1980s. I mean, that really is something which ought to get our attention. If we don't have a written down statewide strategy about healthcare, how many beds do we need in the hospital? How many beds don't we need? Where should we be delivering outpatient care? How are we delivering it? How are we keeping people out of the ER? How are we getting them seen by their doctors on weekends to drive down costs and increase care? If we're not asking ourselves those questions at a statewide strategic level, then we're not doing everything we can for healthcare in this state.
General, thank you. In fact, if I was to walk upstairs, on my nightstand, I have exactly what you're talking about. It's written in 1989. It's about that big. It's GBC bound, and I think it's typed. It wasn't even used on. It was done on a computer back then. It might have been, but it was currently might have been mimeographed on a mimeograph machine. But I have it. That is the last time we've done one. Over 3 decades have gone by before we've done a health system healthcare study. I think we can build off clearly the work that Neil Steinberg has done from the Round Foundation. Clearly, that education, great work there. And they've also done work in the area of health care, really the health system, right? Going back to that. What I was also looking at with regards to what do you need was from a Rhode Island general law perspective, because everything you do is governed by the law, right? You say like some places, some AGs don't have the DA capability that you have. You have that. I'd ask you to be thinking about it, maybe not tonight, but if there are changes needed to Rhode Island general law to help facilitate having a more robust Hospital Conversion Act process, it'd be worthwhile to see what that needs to happen, because this is only going to continue. Well, maybe not. Uncertain what's going to happen. So.
Yeah, Senator. Look, I'll give that some thought. I think one thing that we shouldn't overlook here is our lack of a strong consumer protection statute here, and I'll tell you why that's relevant to healthcare. It's relevant to healthcare because our consumer protection statute, the Deceptive Trade Practices Act, does not give this office authority, at least in the context of a fairly old now but still existing Supreme Court case, to do robust investigations where something is regulated by another agency. So we have the Hospital Conversion Act, but that really cabins our authority. We have the Health Care Advocate Statute, which also gives us some broader authority. But I will tell you, whether it's in the context of healthcare or public utilities or other consumer-related issues, and healthcare, let's face it, healthcare today is a consumer issue. Getting our Deceptive Trade Practices Act fixed would be a huge step forward. Again, the Senate has been very helpful there the last 2 years when we brought that legislation up to the Hill. If we can ever get that over the hill, that would really be a strong thing, not only in the context of healthcare, but for Rhode Island consumers generally. It would really allow this office to do, as I said, what our principal job is, and that is to be the people's lawyer in healthcare and in many other places. Insurance is another great area that would be included there. You know, we acted, frankly, pretty loudly and pretty strongly when rates on the individual market healthcare rates went up last summer. You know, there was not a lot of my statements were not necessarily broadcast far and wide, notwithstanding my efforts to do that. But there's another area where this office can be more active, and if we need a good tool in our toolbox to help Rhode Islanders, it's certainly that Deceptive Trade Practices Act. I think we're doing okay with the HCA, but that Deceptive Trade Practices Act really needs a fix. It's about the worst statute in the country.
Yeah.
General, thank you very much. And I'm going to give you back 12 minutes of your time. We'll keep you 12 minutes later the next time we see you. But thank you very much. I want to thank all the senators who are joined us tonight. Thank you to Katsuka Perez from the Legislative Policy Office, Lisa Cartier, who represents the Hagen tonight. Not really Richard, it's Lisa from the President's legal staff, and Kristen Sylvia, the Senate legislative leader for the Senate. So, folks, thank you very much.
Thank you. Thank you.
Thank you.
Thank you.
You're welcome.